The next case on the docket is Jennifer Palma versus J.P. Morgan Chase Bank. And appellant, whenever you're ready. You're welcome.
I'm Mark Stopa, counsel for the appellants. May it please the court. I would request 5 minutes for rebuttal.
Okay.
Your Honors, every state in the country that has adjudicated the issue at bar in the last 36 years has ruled that a foreclosing lender cannot foreclose without having complied with HUD regulations when it's an FHA mortgage. Every single one, including Florida. As a result, I have spent much of the last several years going from county to county obtaining orders, which I have provided to Your Honors with notices of supplemental authority from circuit court judges that say that HUD regulations operate as a condition precedent in an FHA mortgage. Judge Lisa Davidson, who's overseen the foreclosure division in Brevard County for the last several years, rules that way. To the other coast, Judge Merritt, who's overseen the foreclosure division in Hernando, has ruled that way. Judge Falvey in Citrus. It's almost nonstop. The problem is that occasionally I encounter a circuit court judge, such as in the case at bar, who basically says, well, there's no DCA decision that requires me to dismiss or to rule that that HUD regulations are a condition precedent, so I'm not going to dismiss. Your Honors, this is an issue of first impression, and I submit it is time to issue the written decision on what essentially everyone knows to be the law in this industry and in this area, and that is that face-to-face counseling requirements are a condition precedent in an FHA mortgage because the HUD regulations are specifically incorporated into the terms of the note and mortgage. It's usually paragraph 6 of the note, and this one is paragraph 7. Paragraph 7 of the note and paragraph 9 of the mortgage are very clear. This loan does not authorize acceleration or foreclosure if not permitted by HUD regulations. Now, where I want to start is paragraph 22 of the standard Fannie Mae mortgage is obviously a condition precedent. There's no dispute about that. Okay. One of the things I would implore, request, whatever term Your Honors want me to use, please ask my opponent, how would the notice requirement in paragraph 22, how would that be a condition precedent, but this be an affirmative defense? There won't be an answer to that. I argued that in the initial brief. They had no answer to that in the answer brief. There won't be an answer to that. There is no answer to that. The paragraph 22 is a condition precedent, and the HUD regulations in an FHA mortgage are as well. Several reasons why that's the case. First, if you look at paragraph 22, everyone refers to paragraph 22 and associates it with the notice requirement in a Fannie Mae mortgage. But if you look at that entire paragraph, what that paragraph actually is that's the paragraph that sets forth the remedies upon a default. When there's a default, that's the paragraph that says that the lender can accelerate and foreclose. What do they have to do to accelerate or foreclose? They have to send that notice. That's what the courts all deem a condition precedent, sending the notice, the condition precedent to acceleration. Well, the remedies paragraph upon a default in an FHA mortgage is in paragraph 9. And that paragraph provides, if you want to accelerate and foreclose, if you want to invoke your remedies upon default, that you have to comply with HUD regulations. So both these conditions precedent are in the remedies provision of their respective mortgages and require something to be done in order to accelerate and foreclose. So there's no reason to treat the paragraph 22 as a condition precedent while treating this issue as an affirmative defense. And I submit that the Diaz decision from this court employs that very logic. Now, Diaz is obviously factually different because in that case, the borrowers argued that HUD regulations applied when it was an FHA mortgage, and when it was a Fannie Mae mortgage, and obviously the Fannie Mae mortgage does not incorporate HUD regulations. And in that case, this court said, and I think it's very telling, how this court essentially has already agreed with my position on paragraph 22, because it's the comparison here, because what it said is, unlike scenarios where conditions precedent are ascertainable on the face of a written contract, such as compliance with paragraph 22 of the mortgage, or where a promissory note specifically incorporates the HUD regulations into its terms, it's by no means clear the HUD regulations apply to the instant loan and litigation. So in that case, it wasn't clear that HUD regulations applied because the HUD regulations weren't even mentioned in the mortgage. And in so ruling, this court compared that to paragraph 22 of the Fannie Mae mortgage, or where the promissory note specifically incorporates the HUD regulations into its terms. That's exactly what you have here. And by putting those two in the same breath, paragraph 22 and HUD regulations, this court has already agreed with what I think is the operative distinction, where the note and mortgage specifically incorporate the HUD regulations, just like paragraph 22. That means that it has to be a condition precedent and not a defense. Now, my opponent will ask this court to grab onto some decisions from other DCAs which are not on point. The Knight and Laws decisions are not on point from the first and fourth DCA because those cases emanate from the summary judgment context. And in the summary judgment context, the burden of proof is always on the movant. So those DCAs never had occasion to actually decide the issue at bar. That is, who bears the burden of proof at trial. Because at the summary judgment context, again, it was the movement who bore the burden of proof. And in the Laws case, actually, the homeowner pled it as an affirmative defense, HUD compliance, as opposed to a condition precedent. So those DCAs never had occasion to address the issue at bar, which is this a condition precedent or an affirmative defense at trial? That issue was not addressed in those cases. That's why this is not only an issue of first impression in this court, but it's an issue of first impression in the entire state of Florida, notwithstanding Diaz. So that's the first reason why Laws and Knight do not control the outcome at bar. And the second reason is, the reason I started out by saying it's 36 years. Every state in the country that's ruled on this for the last 36 years is because it was about 36 years ago that Congress codified this regulation into law, and the HUD regulations were incorporated into the terms of the standard FHA mortgage. Before that, in the late 1970s, this HUD issue existed just in a handbook. It hadn't yet been codified into law. And the DCA decision that Laws and Knight cite in that regard is a case from the late 70s called Cross from the 4th DCA. But it's very important that this court understand that at that point, it hadn't been codified into law, the HUD regulations, and wasn't part of incorporated into the terms of the standard FHA mortgage. So that's why the 4th DCA in the 70s said, well, this is simply a defense as opposed to a condition precedent. Okay? Well, it's time that we clarify in a trial, when it is, now that it's been codified into law, that this is a condition precedent as opposed to a defense. And that distinction that I made about it being codified into law is one that several courts in other jurisdictions have made clear, that I've cited in the briefs. Several courts in other jurisdictions have made clear, hey, that was back in the late 70s, this didn't even exist as a law. So that is the operative distinction, and that explains why those Florida DCA decisions are not on point. I'd also note that in the Knight case, the lender actually asked the 4th District to rule that these are not conditions precedent, but the 4th District did not do so. Instead, it simply resolved the issue on the summary judgment
Let me
stage.
ask you this, because I'm trying to go back through my notes and I can't find it, but what did the bank's witness testify to with regard to their knowledge of whether or not the HUD requirement was done, whether they had the sit-down meeting and all of that? Was there any testimony as to whether or not the employee that testified had any knowledge of whether that was done?
She knew nothing, and she was clear that she knew nothing. All that they had was the sending of a letter, okay? And so in the plaintiff's prima facie case, that was all that they had, was the sending of a letter. And
She wasn't aware of it, but she said the standard practice was to have the sit-down meeting, correct? That's exactly the testimony.
I think that that's fair to say, But I think that as we went through the documentation, and there's questions as to the admissibility of that statement, but in terms of the evidence in this case, the only thing that they had was the letter.
Well, it's
and
more
that's-
than the documentation, it was a testimony from the witness. The witness was not aware and saw no documentation that the meeting had actually taken place, although the standard practice of the bank was to have the sit-down, correct?
I think that that testimony did take place. I don't think that that justified the entry of a foreclosure judgment or satisfaction of this condition precedent. You know, that's tantamount to saying, well, it's our standard practice to have possession of an endorsed note before we file suit or something like that. You don't get away with proving an element of your prima facie case by saying it's your general practice or procedure in order to do so. And I think as we dug into that issue, the witness clarified she didn't have any documents. Her knowledge was limited to documents. And second, she didn't have any documents showing that any counseling was done, and no documents showing that a trip was made to the mortgage property. Now, the mere sending of a letter is not one of the exceptions to the face-to-face counseling requirement in the regulation. The reasonable effort is defined in subsection D, and it requires both the sending of a letter by certified mail and the making of a trip to see the mortgagor at the mortgage property. Here, there was no evidence at all of a certified letter in the plaintiff's prima facie case, and there was no evidence at all of a trip to the property. Then, on top of that, in our defense case, my client testifies there was no certified letter, so it was undisputed there was no certified letter, and testified there was no face-to-face counseling, so it was undisputed there was no counseling, and testified that there was no trip to the property, so it was undisputed that that didn't take place either. Now, I think that the case should have been dismissed at the involuntary dismissal stage at the close of the prima facie case because the plaintiff didn't prove compliance with that condition precedent. But certainly, it should have been dismissed at the close of all evidence once it was clearly undisputed that there was no counseling and none of the 5 exceptions set forth in the regulation applied. So I don't think that's even close. It certainly had to be dismissed at one or the other, if not the first and the second. Now, Your Honors, my opponent in the brief talks about, you know, I think the law is so clear and the facts are so clear. That's why they start to talk about issues like, well, we were the pleading issues or we were surprised by this. Surprised by this? Your Honors, I ask you, look back at the record and see when we filed a motion to dismiss on this face-to-face counseling issue, their response to the motion to dismiss at page 42 of the record told us that this should be specifically denied in our answer pursuant to 1.120C. And that's exactly what we did. We specifically denied in our answer. And then what happens? They come to trial and they introduce the default letter as part of their prima facie case. The default letter was only relevant to prove this face-to-face counseling issue, so they litigated the issue by consent. We pled this issue appropriately based on this court's decision in Bolt B and a long line of cases that explain what type of specificity is needed for denials under paragraph 22. We clearly pled it sufficiently, and they litigated the issue by consent by introducing the letter in their case. And we pled it the way that they told us to in the response to the motion to dismiss and the way that the law says we specifically denied under 1.120C when we said in our answer, denied specifically and without limitation, the plaintiff failed to comply with the face-to-face counseling requirements of 24 CFR 203.604. That's exactly what this court has repeatedly said in the paragraph 22 context is how you plead the issue. It's specifically denied by saying you didn't comply with paragraph 22. That's it. So, and then they resort to this prejudice analysis, which is specifically precluded by the Florida Supreme Court because you can't have a prejudice analysis for a statutory condition precedent. And this is a statutory condition precedent because this isn't like a contract that's in theory drafted and negotiated between the parties. This was drafted by Congress. This regulation was drafted by Congress. So this is a statutory condition precedent as opposed to a contractual one. So as a result, you don't have a prejudice analysis and you can't have a substantial compliance analysis. You don't get to rewrite the statute by saying, well, I think that they came close enough or something like that. But even if you did have a substantial compliance analysis, this court's substantial compliance decisions make clear if you're missing an element, if you're missing an entire element, that doesn't substantially comply. And they were completely missing the element about making a trip to see the mortgagor at the mortgage property. So even if you were somehow employ a substantial compliance analysis, they can't get there because they didn't, that's the element that they're going to want to go under, the reasonable effort. That's the only one they could possibly talk about, because certainly none of the other ones apply, but they didn't make a trip to the property. And there are two decisions from other jurisdictions, Mahaffey and Teed, which make clear the plain language of the regulation is also clear. You have to have done a reasonable effort, made a trip to see the mortgagor at the mortgage property, and sent a letter by certified mail. They didn't make a trip to the mortgage property, and the letter was not sent by certified mail. And that's undisputed, it was not sent by certified mail. Certainly undisputed after the defense case rested. The certified mail requirement is obviously important. Why? Congress says it's important. You can't rewrite that portion of the statute. And it's obviously important as a way to make sure that the person gets the letter, right? When something's sent by certified mail, that's obviously something the typical homeowner thinks, this is more important, I better pay attention to this. And it's a way to ensure receipt. It didn't happen. So, with that said, I'll save the rest for rebuttal, because I'm anxious to see what my opponent has to say about some of this, especially if your honors can ask the question of why would this be different than paragraph 22. Thank you.
Good morning, Your Honors. May it please the Court. Aaron Daniel on behalf of the appellee.
Mr. Daniel, before you start off, was this an FHA loan?
Well, Your Honor, that's a good question. And in our briefs, we put forth the argument that, based on Diaz, there is an ambiguity in the record, based on the evidence, whether this loan was federally insured. Now, I agree that this case is not factually...
No ambiguity in the record before the trial court based upon your witness's testimony, is that correct?
The witness testified, yes, this is an FHA loan, but they were talking about the mortgage itself at that time, and the mortgage itself does state it's on an FHA form, and that is a distinction between this case and Diaz.
And you never attempted to clarify that with the trial court, is that correct?
No, Your Honor, and there's a reason for this lack of evidence and ambiguity in the record, and the reason is that this failure of condition precedent wasn't pleaded with specificity. And respectfully...
They made a denial that the condition precedent was, that you performed all conditions precedent before filing the lawsuit. Why isn't that enough?
Correct, Your Honor. Let me read you specifically that specific denial. In the answer, denied, specifically and without limitation. Anything that follows after that statement is definitionally not specific and with particularity. It's open-ended, without limitation.
Well, the mortgage was specific, right?
The mortgage, again, was printed on the FHA form, and there was indicia that it might have been intended to be an FHA loan. However,
But the mortgage, as far as the acceleration and notice and the meeting, that was all very specific. Anyone reading the mortgage, reading all the paragraphs, taking them all together, would understand the specific requirements prior to foreclosure, correct?
Correct, Your Honor. And there's one more requirement I'd like to direct your attention to in the mortgage, and that's in Section 9E, which expressly contemplates if the application for federal insurance is not approved. And 9E says that after 60 days, if we haven't gotten our approval for insurance on your mortgage, we have the right to foreclose. We may foreclose. And so that contemplates that the mortgage form itself is not going to bind the lender to requirements that exist only if they get the federal insurance, because it's a balance. You get the benefits of the federal insurance, but you also have the burdens of the requirements. But if there's no benefit, and there's no evidence that there was benefit here, then there's no burden. And in fact, the HUD regulations themselves define what an insured mortgage is. And those are sections, let me get this.
But once your client said, your witness said, yes, it's an FHA mortgage, why is that not the end of the inquiry unless you choose to somehow show that, well, it's on an FHA form, but that doesn't mean it's an insured mortgage, and that doesn't mean that the HUD requirements apply.
Your Honor, I agree that the evidence could have been better developed on this issue, and it should have been. And that gets back into my pleading specificity argument.
Okay,
that-
let's talk about that. And I'm looking at their denial of paragraph
Correct.
8, which is the allegation that all conditions precedent have been performed, have
Correct.
occurred, been excused. It says, denied, specifically and without limitation, plaintiff failed to comply with the regulations of the Secretary of Housing and Urban Development, including but not limited to, and that's when you stopped. It goes on and says, including but not limited to the obligation to provide face-to-face counseling in 24 CFR, and he cites the exact section and subsection. As to that provision, how much more specific can it be?
Your Honor, we submit that those qualifications of without limitation and but not limited to negate any contention that that's the only condition precedent that they were raising. In fact, they raised others. And this
Maybe it isn't the only one, but doesn't it tell you that they are raising that one?
It does, Your Honor, and,
Okay.
just to get the timeline on how this defense developed, there was the motion to the motion to dismiss, which raised specifically that face-to-face meeting, and then our response saying, this is a fact issue, please raise it as an affirmative defense. They still raised it as a denial, but then they expanded it into without limitation, but then they expanded it into all these other conditions precedent. So at that point, the condition precedent expanded. The scope of that issue expanded.
You make it sound like they pled that so that they can bring in some obscure argument that's made later on in the case, because the whole point is to put the opposing party on notice as far as exactly what are the deficiencies.
Correct, Your
That
Honor.
was the issue that was litigated throughout the trial, is that correct?
2 points on that, and I'd just like to make the first point on specificity. This exact denial, specifically and without limitation, was considered by the second DC in the Quinian case and rejected as unspecific. And there, it was a FCCPA condition precedent. And they cited, as here, the FCCPA section. And the Quinian court said, that's not enough because you have to specifically allege the nature of the failure of the condition precedent, and you have to allege the nature of the non-compliance. So here,
Failure was the failure to hold the meeting or even request the meeting, correct?
correct, Your Honor, but there are, as counsel has discussed, many different exceptions and many different reasonable effort, 2 different prongs to the reasonable effort. And so it's unclear whether or not
Well, it's up to you to argue the exceptions, correct?
it is up to the defendant to properly frame the issue through the pleadings.
Well, they framed the issue, failure to conduct the meeting.
Failure to conduct the face-to-face counseling in accordance with this regulation, or not limited to others, but how did that failure occur? Was it the failure
It was
to?
litigated with the trial court, wasn't it?
Your Honor, it
Your
was,
witness was asked, was a meeting conducted? Your witness's answer was, I don't know.
I do not know. That was the testimony, correct, Your Honor.
And then Ms. Palma was asked whether a meeting was held, whether a meeting was requested, and what was her answer?
She could not remember, although I believe she actually did testify affirmatively, no, that there was never a face-to-face meeting.
And her
We had
testimony
telephone
was,
conversations.
if there was going to be, if someone had requested a meeting, she would have appeared at the meeting, correct?
I'm glad you brought up that because it brings up my prejudice point. And that is, in that discussion of whether or not she would have gone to a meeting, there was also a discussion of what would have happened at that meeting. And she said that in June, by the time she defaulted, she had lost her income. She did not regain an income until October. That's the entire period for which the face-to-face meeting is supposed to occur. And she testified that she had no income, so if the face-to-face meeting had occurred, there was nothing that would have happened at that meeting that would have prevented further default.
How can you say that you know what would have happened at a meeting that your client didn't offer?
Because, Your Honor, the burden is on the defendant to prove the prejudice when there's a failure of condition proceeding.
Well, let's take as a hypothetical. Prior to the meeting, Ms. Palmer consults with her lawyer, and her lawyer says, before you appear at this meeting, it would probably behoove you to have a job so that you can show your ability to pay any amount on the loan as an attempt to work it out or to have alternative payment arrangements. If that was the case, would that change your argument with regard to prejudice? If she was able to present to the meeting the fact that she had a job, maybe at a lower income than it was when she initially signed on the loan, how does that change?
Under that hypothetical, if there is evidence of her ability and that evidence that she had consulted and was preparing, would have prepared, then I think you have demonstrated a prejudice. But here, there's no evidence demonstrating the prejudice.
But that's
You didn't
because
also-
nothing happened. There was no offer of a meeting, to use Judge Wallace's hypothetical, no offer of a meeting that would have sent her to a lawyer to get the advice to prepare for the meeting. Why do you get the benefit of the doubt when your client doesn't do what the law says it's supposed to do?
Your Honor, because that is the standard that has been applied in this court's condition precedent prejudice analysis in Gorel and in Vasilievsky.
But not when there's a failure completely of the condition precedent.
Your Honor, respectfully, we submit that there is an indication that substantial compliance may have occurred, and that's in the default letter that was sent. There is mention of, we have one-on-one meetings available, please contact us, please contact us, please contact us.
If the note says, this note does not authorize acceleration when not permitted by HUD regulations, and the HUD regulations say that you have to have a face-to-face meeting, how is that not a condition precedent to instituting the foreclosure? And if it is, then the burden is placed on you, the lender or your client, to show compliance at trial. So how is that done in this case? I mean, that is, if it is a condition precedent and it was not shown by your client, then it's a complete, then it's different than paragraph 22 says we can't file, we have to wait 30 days to file, and we filed it in 28 days. I mean, it's significantly different than that.
A few points on that, Your Honor, and that's getting into the whether or not this is an affirmative defense or a condition precedent. And to hold that this is a condition precedent and place the burden on the lender would be to strictly interpret the HUD regulations.
Why would we not follow what the statute says?
Correct,
It's not my job to rewrite it.
The regulations, Your Honor, do not govern, and the out-of-state case law is clear on this, that the regulations do not govern the relationship between the lender and the borrower. The borrower is an incidental beneficiary to that relationship between the government and the lender through the regulations, and that's why they have not been strictly applied. Every jurisdiction outside of Florida that has a judicial foreclosure process has interpreted that regulation to be an affirmative defense. Every out-of-state jurisdiction that does not have a judicial foreclosure system has interpreted it to be a condition precedent because they've said that as incidental beneficiaries, the borrowers do have an ability to assert the regulations defensively, but in non-judicial foreclosure states, without the ability to assert an affirmative defense in an action, the only way to do that is to challenge the condition precedent either through an injunction, when there's a power of sale attempt, or after the fact through a collateral attack. And so the only judicial foreclosure jurisdiction that is split on this is Ohio. And I would direct the court's attention to the Gerbil case out of Ohio. That's the second district in Ohio, appellate district. And they've held that it's an affirmative defense, and their analysis is consonant with the law in Florida in that they apply the laws of equity. They say foreclosure is an equitable process. It is a creature of the common law. Therefore, to interpret these regulations strictly would place too much of a burden. It would be too harsh on the lender. But
So we don't,
equity,
so the lender does it, so the lender and the person who buys the home don't have to abide by the contract that they sign.
absolutely they have to
Right.
abide by the contract, but the contract itself doesn't incorporate the express conditions precedent. It doesn't say this section shall be followed. It does say you have to follow all the regulations. But
This note does not authorize acceleration when
Correct.
not permitted by HUD.
correct. So you have to look at all the HUD regulations outside of the note, and the cases outside of Florida that are judicial foreclosure states have said, we looked at the HUD regs, yes. We determined that it can be used as a defense to foreclosure under equity. And that's what Florida has, an equitable foreclosure system that allows the borrower to defensively assert these regulations, which were not in place primarily for their benefit, but incidentally. And thus, that is the reason that they are treated as an affirmative defense. So we would suggest that Florida continue in its practice of treating this as an affirmative defense, as this court did in Diaz and the prior cases, and follow every other judicial foreclosure state in the country and the second district in Ohio and treat it as an equitable defense. Your Honors, for that reason, we respectfully request that you affirm unless there are any other questions.
Does your argument rise or fall on whether or not we determine it's a condition precedent or an affirmative defense?
Your Honor, no, we respectfully request that you look at the unspecific denial as well as the prejudice, the lack of prejudice, and we submit that there is a lack of prejudice there, and that was the burden under Florida law for the defendant.
Were you on notice of this particular deficiency by the pleading? Whether it's phrased as a denial of condition precedent or an affirmative defense?
Your Honor,
Were you on notice?
we maintain that that was not sufficient enough to provide notice for us to prepare a sufficient defense. Based on all of the regulations, there are many other regulations in HUD that could have been raised. It was simply not specific enough, and the burden is on the defendant to specifically frame how, which condition precedents, and how, and provide facts for that. And this was just a conclusion, there were no
But
facts.
by identifying this particular one, were you on notice that they were going to raise that particular one? Separate and apart of from who has the burden of proof?
We were on notice
On
that
notice
it was,
they would raise that one.
we were on notice that in addition to many others, Your Honor.
Okay, but let's focus on that one. So regardless of who had the burden of proof, if your client had the burden of proof, she said, yes, it was an FHA mortgage, and I don't know if they did the counseling. So that would be a failure of proof, correct?
Your Honor, we would suggest that the burden is still on the defendant.
I'm saying
At that
if it
point.
was on the plaintiff,
If this is treated as a condition precedent,
right?
and if our witness's testimony that, yes, this is an FHA, almost an off-the-cuff testimony, we would submit that that was one piece of evidence among all the other evidence that was submitted, and that was for the trier of fact to determine and sorting out the evidence whether or not this was federally
She
insured.
didn't offer any evidence to prove that, the plaintiff didn't offer any evidence to prove that the counseling took place, correct?
There was no evidence, Your Honor, correct. There was only the
Then on
default letter.
defense- And then on the defense side, if we assume it's the defense burden of proof, the defendant put forth affirmative evidence that there was no counseling offered or held, correct?
Yes, Your Honor.
Okay, and that was not rebutted by the plaintiff?
No, Your Honor. There was only the default letter that was sent, which may or may not rise to the level of substantial compliance.
So why would it not be correct to say that if it was the plaintiff's burden, the plaintiff didn't prove that it happened? And if it was the defense burden, the defense proved that it did not happen?
At that point, you engage in the prejudice analysis, Your Honor.
Setting that aside, just leave my question where it ends. Why is it not correct to say that if it's on the plaintiff didn't prove it? If it's on the defense proved that it didn't happen?
Your Honor, we would suggest that we didn't have a fair opportunity to prove it, and that's why there wasn't the evidence.
I have some difficulty with that, because there was a motion to dismiss that was filed early on that raised the argument, correct?
Correct, Your Honor.
And so if you were put on notice at the prior motion to dismiss of what this argument was, I find it difficult to understand how you're not on notice and wouldn't be prepared for that come trial.
Your Honor, to answer your question, then there was the intervening answer, which provided this shotgun without limitation, open-ended denial.
You're not selling me on that argument, because I don't know how much clearer they could have been.
Well, Your Honor, I would respectfully request you to look at the Quinian case, which has rejected that specific denial as unspecific, and look at the factors that case considered.
I will do that.
My time is up. Thank you.
I have one more question, though.
Yes.
To follow up on what Judge Orfinger was asking you about. So as far as the burden of proof goes, your position is this is an affirmative defense, which, another way to say that is it's an avoidance, correct? By the
Correct.
Defendant admits, if you assume these facts are in place, we still have no liability based upon this additional fact that there was no meeting.
Correct.
Okay. So in this case, you were asking the defendant, Ms. Palma, to prove a negative, which is the meeting didn't take place, for her positive or affirmative defense. Is that correct?
Your Honor, she testified that it did not take place. Correct. So that was enough to establish that the meeting did not take place. But then, as part of that affirmative defense, as part of that burden, the defendant still has to show the prejudice, because there is a prejudice analysis in this district, and that is part of the burden to demonstrate the prejudice. I had an income, I would have been able to rectify the default.
Well,
had the meeting
part of her
occurred.
prejudice could have been, had I been given the benefit of the meeting, I would have been able to mitigate damages and provide some sort of payment, which would have resulted in the foreclosure not taking place, correct?
And that would have been evidence and testimony that she would have had to produce. And additionally, just the purpose of the face-to-face meeting is not to necessarily mandate that the lender enter into some kind of forbearance. It is, in our brief, we have a case from a pullout from the HUD guidebook that is to have the face-to-face meeting to provide sort of financial counseling. And so any financial counseling where there is no income would result in no mitigation. So, Your Honor, that is part of the burden that the defendant was required to prove. Thank you, Your Honor. We respectfully request that you affirm. Thank you.
Thank you. And you have just under 5 minutes, counsel.
Your Honors, the Quinian decision is in the 559-715 context, and from the Second District, it's pretty clear that that decision is predicated on how the DCAs, frankly, just didn't want me to win on 559-715. This court is bound by Cologne, Samaru, and Boltby. 3 decisions from this court on the pleading issue, which all make clear that where the statute or paragraph 22 is identified and the specific denial says that the plaintiff didn't comply, that is a sufficiently specific denial under 1.120C. Boltby, Samaru, Cologne, all from this court, all binding, all directly on point, no case law to the contrary. My opponent doesn't even mention those cases at all. Those are the binding decisions on that issue. Even if they got past that, he had no argument at all about how they litigated the issue by consent in their prima facie case. case by introducing the default letter. The default letter had no relevance at all in their prima facie case except for the face-to-face counseling issue in the regulation. So I cited this court's decisions in Book and Vangeria, and they didn't mention those cases or any contrary case law. Clearly, that issue was litigated by consent as well. My opponent talked about paragraph 9E of the mortgage, but a condition precedent is their burden of proof. This court's decision in Boltby says that, or look at the Florida Supreme Court standard jury instruction on conditions precedent. Proving a condition precedent is on the plaintiff, it's the plaintiff's burden at trial. So if they thought that something about 9E satisfied their obligation, it was their obligation to prove it. And my opponent admits, and the record is clear, there was no evidence supporting anything pertaining to do with 9E. So that's a non-starter for them. So this relegates them to arguing prejudice. And Judge, Your Honors, I submit that you take a look at two things. First, my opponent didn't even mention StressCon and didn't even talk about how the Florida Supreme Court case, which says if there's a statutory condition precedent, you don't engage in a prejudice analysis because it's not up to Your Honors to rewrite the statute or the regulation. If Congress thought that prejudice should be an element in the regulation, it would have said so. It didn't. So it's not up to Your Honors to rewrite that regulation to include it. But even if you somehow got past that and thought prejudice was a factor in the analysis, look at the Florida Supreme Court decision in Macias, which is cited in my reply brief. The burden of proof for a condition precedent is on the plaintiff. So when a plaintiff just has a wholesale failure to comply with an element, even if you thought prejudice was a factor, prejudice is presumed. That's what the Florida Supreme Court says in Macias. Now, I understand this court has some contrary decisions in Gorel and Vasilevsky, but one of them, those is in the summary judgment context where you're not assessing the burden of proof at trial. And the other one, Gorel, was simply dicta because this court reversed on the standing issue. So this court hasn't adjudicated whether prejudice is an issue at trial in these cases, or if it is, whose burden it is, particularly in the context of a statutory condition precedent. But even if they got past all that, my client proved the issue of prejudice in the defense case by saying she wanted the counseling, would have participated, and had she gotten the breach letter, that she would have cured the arrearages. And all of that was undisputed. But Your Honors, I submit that the decision that you write here, what I ask you to write, is the decision that I've been pushing for years, that somehow hasn't been written yet, that says this is a condition precedent. Judge Rohrfinger, I really appreciated your analysis when you were asking my opponent at the end, well, if it is a condition precedent, you didn't prove it. And if it is a defense, then they did prove it. And I could understand you may perhaps have a temptation to write a decision that simply says, well, either way, this needs to be reversed. And actually, Judge Falvey, in one of the supporting authorities that I gave, Your Honor, did just that at a trial. But I ask that you do more than that. I ask that you write the decision that all the circuit court judges need that say this is a condition precedent in a HUD mortgage. Your Honor's basically already said that in the Diaz case. You already made the operative distinction. Now I'm just asking you to say it. This shouldn't have gotten to the defense case. We shouldn't have had to put on a case. This should have been involuntarily dismissed at the close of the plaintiff's prima facie case. This was a condition precedent. They knew it was a condition precedent. We proved it sufficiently, and they didn't prove. We pled it sufficiently, and they didn't prove the issue. And the last thing I want to be clear about, whether it's an FHA mortgage or not doesn't turn on what a witness who has no knowledge about this at all may testify. It turns on the content of the document. The note and mortgage specifically incorporate the HUD regulations. That's what forces them to comply, not what the witness testifies at trial. So for those reasons, I submit this court should reverse the final judgment at bar, remand with instructions for an involuntary dismissal, and say via written opinion that this is a condition precedent in an FHA mortgage. Thank you very much.
Thank you.